Hello friends, welcome. Friends, yesterday Vodafone Idea filed a fresh petition before Supreme Court seeking a waiver of 30,000 crores on AGR dues. Now friends, those who are following this sector might be really surprised what is going on. Why? Because this case, which is adjusted gross revenue of the delta amount due to DOT on account of the license fee and spectrum fee calculated on the total revenue than only on the telecom part of the revenue, was fought for 20 years and various legal remedies were tried by various players in past and they lost. And they lost at the Supreme Court level. So this fresh petition which Vodafone Idea has filed before Supreme Court now must be looking as a surprise because all legal arguments were exhausted, including the curative petition. Right? So how can Vodafone Idea come out with a fresh petition when every legal remedies were exploited and they lost? So in this video, we are going to explore that. What is this new case? What are the likely legal arguments? Whether they are new or they are old? And what is the likelihood of success of these arguments before the Supreme Court? That's all we are going to discuss in this case, in this video, and you will find this video pretty interesting. So friends, what I have done is, I have created a slide deck as I always do, and I will take you through the slide deck so that the argument is structured and I don't waste any time of my viewers, digressing from the key argument. So the thoughts are anchored in the right direction and we'll go step by step. So the title of this presentation is Vodafone Idea's AGR petition of 2025. Why it is not a review, but it is a plea for justice. Means what is the distinction between what they did in past and what they are doing right now. We are going to explore this argument legally and see whether there are some provisions which exist under the framework of Constitution of India which can give some hope to Vodafone Idea to get some respite. And that's all we are going to discuss in this video. Let me just take a different pen color before I take you through this slide, the next step. Now, the background of the AGR case, a recap. Now, those who have not followed the AGR case, right, must be living under the rock because everybody in India knows who are following the telecom sector what is this AGR case, because this has completely dismantled the overall competitive dynamics of the telecom industry and has now put Vodafone Idea's survival at risk. Now, why Vodafone Idea survival is at risk? Because the dues on Vodafone Idea as per 31st March 2024 was around 74,000 crores, and their next installment after the moratorium period which the government gave as a part of the telecom package in 2021 ends on September 25, and after that there is a due of around 16,500 crores that Vodafone Idea has to pay to the government before 31st March 2026. And that's why there is an urgency to settle this before that date, because Vodafone Idea doesn't have enough cash to make that payment because their overall revenue is around 40,000 crores and their EBITDA margin is only 40%. So they really don't have the money to pay that 16,000 crores. That's why, let's recap the case under this particular context. AGR is adjusted gross revenue. What it basically means is that this is the foundation on which the license fee and spectrum fee is calculated when the fixed license regime was converted into revenue share in 1999. And the definition of AGR was supposed to be decided later. Means adjusted gross revenue definition was supposed to be decided later. Operators were contesting that only the telecom part of their revenue should be treated as a base for calculation of license fee and spectrum fee. And DOT was saying, no, it is the total revenue which includes telecom and non-telecom. As a result, there was a certain delta amount which was left unpaid. And that delta amount, which is the principal, which got accumulated because the case was fought for last 20 years, resulted in a huge culmination of interest payments, penalties, and interest on penalties, which were 4 times the principle as regards Vodafone. So if you look at the Vodafone dues at before the moratorium period was 58,000 crores, of which 30,000 crores was interest on penalties and penalties, right? So this is what the Vodafone Idea is seeking a waiver before Supreme Court in their fresh case. Now, just let's recap the timeline, because these timelines, especially starting 2019, is pretty crucial. And when we will evaluate the new grounds of this case, these timelines are going to be very, very important to understand. First is 2019, when DOT upheld, where Supreme Court upheld the DOT's definition of AGR, which is the total revenue, and dismantled the operator's definition of AGR, which was only the telecom part of the revenue. Then, in 2020, Supreme Court came out with a very, very important judgment. And these two judgments are different. And let me explain to you why this 2020 judgment was very, very important. What happened was, friends, after the 2019 judgment, this is the 2019 judgment. Let me just, I think my pen has lost. Let me just go back and get my pen back, and then I'll start again. Just a minute. Show screen buzz. Yeah. So if you look at this judgment finally laid the foundation of DOT's case and said that DOT is well within the right to charge the license fee and spectrum fee on total revenue. Now, DOT then realized that it has become very harsh. The judgment has become very harsh. So they wanted some relaxation. So they filed an application for review. In that application, if you go down below in that application, what DOT was arguing was, let me just show you the exact provision of that application, because this is pretty important. You need to understand what is going on, and what logic was used to ask for this respite. Let me just show you. Yeah, here is it. It is. So this is the mode of recovery, because the recovery part was established. Then mode of recovery was to be decided, how they will recover, in how many installments. So DOT proposed a discount rate of 8% and 20 years. They said, okay, it will be recovered within 20 years, so that to give the operator certain kind of relaxation, so that the impact of the judgment is going to be very, very less. And the arguments that DOT used was based on the impact of competitiveness of the sector. If you look at this argument, adverse impact on competition, quality of service, implication on the banking sector. So said that, okay, that is fine, but because we need to be a little bit soft on the operators, we can't create so much pain on the operators, the whole sector gets dismantled. And they proposed to the Supreme Court a relaxed timeline for payment. And that is where this judgment came of 2020, this one. The dated was September 2020. And in that, Supreme Court did not agree to DOT's demand for a much relaxed payment. So what they said was, they will give only 10 years payment, and the deadline was 31st March 2021. And that is why when the moratorium was given, the spectrum the auction spectrum the deferred payment period got extended, but the AGR payment did not get extended because of this sunset date of 31st March 2031, this sunset date, because it has to be paid from 1st April 2021 to 31st March 2031, and it has to be payable after 31st March for every succeeding financial year, right? So that is why this judgment is very, very crucial. And then in 2024, there was a curative petition which was filed, right? And it was dismissed on August 2024. And the ground of dismissal of the curative petition is here. So if you look at, this is the Supreme Court order, and it's very, very important to understand that. So what Supreme Court did, and on what grounds the Supreme Court dismissed the curative petition, is this case. And we'll discuss this case, the principle of this case, in the subsequent slide. So if you look at, you can pause the video and kind of read the order of Supreme Court, why they dismissed the curative petition, right? Now comes the 2025 BI review, and to me it is not for a review, but to seek waiver of penalties and interest on new grounds, and we will explore what are those new grounds. Now, review and curative petition, why they are no longer valid. So you can't file a review and a curative petition. Why? And let's understand that because this case, Rupa Ashok Hura versus Ashok Hura, which I mentioned here, if you look at this, not this, the curative petition, look at this one, this case, right? So this case, we are discussing, I've laid out the key principles. So curative petition is allowed only if there is a violation of natural justice, and SC said that there was no violation of natural justice in the AGR case. There was no bias or conflict of interest of judge. There was no gross miscarriage of justice. None of these applied in the AGR case. So SC fully heard the matter and no violation or biases were alleged, and therefore they rejected the curative petition. And therefore there is no way Vodafone Idea can either review or file a curative petition because all the legal remedies and all the legal arguments were exhausted. So what VI may not be asking for, they are not asking for reassessment of calculation of dues. Why? Because of this judgment. Look at this judgment of1st September 2020, which I said that, when the DOT filed their modification application and what they said. Look at this. I'll read out this. Look, this is this page number 46. There shall not be any dispute raised by any telecom operator and there shall not be any reassessment. Clearly it is written there. On what basis there will be reassessment? If this is written and cast in stone, there is no way Supreme Court can do any reassessment of their AGR dues. And that's why this Supreme Court judgment, unless the curative application was somehow superseding this judgment and questioning the judgment on those grounds which I just explained to you, which is these grounds. These are the grounds which I just explained. In the Rupa Ashok Hura versus Ashok Hura case, then only you could have dismantled these provisions which were listed out, right? This one. And clearly it was mentioned that how the payment was to be made and when the payment was the sunset date. It was clearly mentioned. And that's why there is no question for any kind of reassessment on recalculation of dues. It is not possible under the current legal framework. So therefore, they are not disputing the definition of AGR, right? Not challenging the principal amount, not reviewing the past argument. They are not, they can't, right? So what probably they are asking for? What Vodafone Idea must be asking for? They are asking for waiver of interest and penalties and interest penalties and interest and penalties. Relief from compounding that multiplied due to 20 years of the battle, because the battle went for 20 years. And therefore, sometimes, if you drag the legal battle to such a long extent, then it may be possible that there must have been mistakes which were committed on various sides. So you can't be considering the harshness of interest penalties and interest on penalties to be levied to such a long duration. If the matter is settled, let's say within 4 years or 5 years, it makes sense. If all the parties did not force for settlement and then kind of went and litigated the matter for 20 years, then the question about the utility of the reasonableness of interest penalties and interest on penalties can be questioned, right, on the ground of reasonableness. So permission for DOT to exercise discretion. So if this case cannot get somehow dismantled, if you see, in the event of any default in making payment of annual installment, that is the which case the 1st September 2020 judgment, which I mentioned, Supreme Court came out after the DOT filed a modification application for a much relaxed duration of payment. They said that there cannot be, as per the agreement, along with penalty interest, the penalty automatically without reference to court, and the court is asking, besides, it will be punishable for contempt of court if these things DOT does not execute, right, or force execution. And let there be compliance order reported by all TSP and DOT every 7th year for each succeeding year. You can look at the harshness of this judgment. So you can't, the DOT's hands are tied. So therefore, if somehow this judgment can be circumvented, then there could be some way DOT can exercise some discretion. And the judicial intervention is possible under Article 142 to do complete judgment, right? So complete justice. So Article 142, I'll show you. If you see Article 142, this is Article 142. Let me just do a zooming of this. And it says that the Supreme Court, in exercise of its jurisdiction, may pass such decree or make such order as it is necessary for doing complete justice in any cause or matter pending before it, and the decree so passed or the order so made shall be enforceable throughout the territory of country. So this is Article 142, under which this matter can be heard, right? Now, key legal grounds of new petition. What are the key legal grounds? As I told you, Article 142, SC has power to do complete justice. It may be possible that partial justice has been done, right? In that case, though they are not questioning the judgment as at large, but it may be possible that even when you are not questioning the judgment is not creating a justice, a holistic justice for every stakeholder who is participating in this whole ecosystem. The justice may have been done for as regards to DOT, right? But what about the consumers? What about the overall ecosystem? If some party is irreparably harmed, then it is possible that somebody who is not even party to the dispute will also get a spillover impact, right? For example, consumers, if the competition in the sector is harmed. So therefore, it is important for the Supreme Court to do complete justice. It can't be seen as a justice to only one party, Department of Telecommunication, right? The way the earlier judgment of 2091 was portrayed. And then right to equality and prohibit arbitrary disproportionate penalties. The penalties looks like was disproportionate in nature because of the judgment which lingered around for 20 years, where both parties, DOT as well as the operator, actually three parties, DOTs, operators, and the courts were responsible. I have already written an article on this subject, who actually is at fault, and I'm going to paste the link of that article in the description. Then public interest, competition doctrine, and legal and legitimate expectation due to prior relief by the government's equity, right? So what is Article 142? I have already showed you. SC can override statutory limits in the interest of justice. And it has already been used in certain cases, allows SC to grant relief when the legal remedies are exhausted, and mapping to AGR, operators can't pay 30,000 crores, Vodafone Idea can't pay, and it will dismantle Vodafone Idea and kind of make the sector completely uncompetitive, and therefore SC has to take that into consideration. SC order is preventing government from, and SC order, the order of 2020, which I showed 1st September 2020, it's preventing the government to do any kind of relief, right? Unless they take the whole parliament into consideration, which is going to be a very uphill task, right? And it is under public interest warrants SC's intervention. Article 14, we know, it can imposition of 4x penalties, interest on penalties on the principal, and a battle which was fought for 20 years where all parties were responsible and everybody contributed to the delay. Penalties are punitive, not compensatory. You actually have to create penalties which are you cannot create penalties to make it compensation. Meaning, what it basically means that the whole idea of penalty is that we will impose penalties so that you don't repeat that action again. But in this case, this question does not allow, because Government of India later in 2021 dismantled their own definition of AGR. So when they dismantled their own definition of AGR and said that from now onwards, we are going to charge license fee and spectrum fee only in the telecom part of the revenues, then what is this penalty all about? Because it is not punitive. It is not, government did not keep their stance consistent. If they had so much, you can say strongly, where, anchored to their primary argument, correct? So state action must be reasonable, right? There are many cases which kind of supports that. Public interest and competitive market doctrine. Telecom is an essential service. VI's collapse would reduce the market to duopoly. It will impact 200 million users. Not only 200, it actually will impact everybody, because once the market becomes uncompetitive, everybody will be at the mercy of the market leaders. You can't do anything. They will give you the worst quality of service, and they will charge you the highest level of tariff, and then it is going to create a problem for you, right? So SC tariff and SC has used public interest in 2G spectrum judgment and natural resource allocation cases, right? The another thing is legitimate expectation doctrine. So what is legitimate expectation doctrine? This is again in legal terminology. which says that what is the doctrine of legitimate expectation. In public law principle, it states that if the government authority promises, represents, or consistently act in a particular way, individuals or companies may deploy a legitimate expectation or similar treatment in future. Because the government has already taken equity, they have again taken a converted principle into equity. So there is a legitimate, it does not mean that they have the right, but it is an expectation that something will be done in later, and the government should be empowered by the courts to carry on that treatment. That is what the main point is. So, executive deadlock due to SC judgment, which I have already explained to you. SC order no reassessment or waiver, and that has to be circumvented. DOT cannot reduce even 1 rupees without contempt risk, which I showed you here, which is there. You see, not this judgment. Yeah, look at this. It will be punishable for contempt in court, right? Then government has already taken 49% stake in VI. SC's own order blocks policy action in future. So VI is seeking a judicial unlocking of these barriers under Article 142. So summary is very simple. The legal option status, AGR reopening versus interest and penalty waiver, right? The review petition, all options have been closed. Curative petition, all options have been closed. AGR reopening, interest waiver, etc. But fresh petition, AGR reopening case has been closed, but interest and waiver on constitutional grounds can be okayed, still open because of the reasons which I explained to you. So the only argument legally open is relief from compounding interest and penalties under Article 142, under Article 14 and public interest doctrine. So the final takeaway of this case is AGR is not about revisiting. This case is not about revisiting the AGR judgment. That chapter is closed. This is about saving the company, its user, public money from disproportionate penalty that grew over 20 years of litigation where all parties were responsible, even the courts, by causing the delay. So it is a new case on new grounds, friends. So I hope, friends, that you have understood this case and maybe that something will be done. I am hopeful because I want Vodafone Idea to survive, and many of my viewers also want Vodafone Idea to survive. So that's all in this video, and I hope that you like this video. And thanks for listening till the end. And let's all hope that on 19th May something positive comes out, because if this 30,000 crores is waived off, then there will be a substantial relief on Vodafone, and their 16,500 crores of installment will go down significantly, and the government doesn't have to take any further equity, at least in this financial year. In the next year, we have to revisit those cases about the spectrum dues. Thanks for listening, friends, and till the end, and I'll come back with a new video next time on a new topic. Thank you very much.